I'm a big fan of officers continuing to be proactive and to take steps to stop crime. That said, in the age of body cameras and media stories trying to paint officers in a negative light, it's incredibly important to make sure that your actions as a police officer are lawful. Today, I'm going to talk about Terry frisks, what they are, and why you should be careful in their use.
I'm Steve Serbalik, and I'm a panel attorney with ASCOPS.
First, the term Terry frisk comes from a 1968 case named Terry versus Ohio. In that case, the U.S. Supreme Court made it clear that when officers have reasonable suspicion, these are more than mere hunches. They have to be specific and articulable facts that criminal activity may be afoot and that the subject may be potentially armed and dangerous. Officers can stop a potential suspect and ask questions. And if these questions don't dispel an officer's reasonable fear for their safety, the officer may conduct a limited pat-down of outer clothing to attempt to discover weapons. Terry stops are where the tactic stop and frisk comes from, a controversial term, no doubt, but here's where I'd like to give a word of warning. First, Terry frisks must be supported by reasonable suspicion. And second, Terry frisks are for weapons, not drugs. If you can't articulate that contraband that you find during a Terry frisk felt consistent with a weapon, be really careful in deciding to remove it from the suspect's pocket yourself. You can ask questions to develop probable cause for a search, but be cautious if you're simply removing objects that don't actually feel like weapons from suspects' pockets during a Terry frisk. If you have any questions or comments about Terry stops or frisks, please leave them in the comment section down below.
Please do me the favor and like this video so that YouTube will show it to more people. Subscribe to this channel and turn on the notification bell. It really helps out. I'm Steve Serbalik. Thanks for watching and stay safe out there.